Before we begin, a quick and important disclaimer. This presentation on the historical evolution of divorce lawyers and their place within American legal education is intended strictly for educational and entertainment purposes. The information provided does not constitute legal advice, nor does it establish an attorney-client relationship. Law is a dynamic field where historical trends and case studies may not reflect current statutes or potential outcomes in specific jurisdictions. Viewers are strongly encouraged to conduct their own due diligence and consult with a licensed professional regarding any personal legal matters or academic research. Imagine for a moment that you are a graduate of Harvard Law School in the year 1890. You have spent years mastering the complexities of contract law, the rigid structures of property rights, and the emerging field of torts. You are a member of the elite, prepared to represent the industrial titans of the Gilded Age. But there is one area of the law you would never dare to touch, a practice so stigmatized that it could result in your immediate social and professional exile: divorce. At the turn of the century, the divorce lawyer was not seen as a champion of individual rights or a necessary facilitator of family restructuring. Instead, they were often viewed as a legal scavenger, a shyster, who profited from the destruction of the most sacred institution in American life. In many states, the divorce rate was lower than the rate of people being struck by lightning, and the legal education system reflected this reality by almost entirely ignoring the subject. Yet, today, family law is a cornerstone of the American legal economy, a multi-billion-dollar industry that occupies a central place in the curriculum of every major law school in the United States. How did we get here? Why did the American legal establishment spend nearly a century trying to bury the study of divorce, only to eventually embrace it as a vital academic discipline? This deep dive will uncover the hidden history of the divorce lawyer's journey from the shadows of the divorce mills to the prestigious halls of the Ivy League. We are going to solve a fundamental mystery for you today: why the American divorce process is so uniquely adversarial, expensive, and complex. By understanding the historical roadblocks that kept divorce out of proper legal education for decades, you will gain a clear perspective on the systemic inefficiencies and strategic maneuvers that define the modern family court system. To understand the historical study of the divorce lawyer, we must first look at the colonial foundations of American law. In the early days of the Republic, divorce was not a judicial matter, it was a legislative one. If a marriage was to be dissolved, it often required a private act of the state legislature. Consequently, there was no need for a divorce lawyer, in the way we understand the term today. Legal education, which was then primarily conducted through apprenticeships rather than formal schools, focused on the Blackstonian view of the law. William Blackstone, the English jurist whose Commentaries on the Laws of England served as the primary textbook for generations of American lawyers, famously described the legal existence of the woman as suspended during marriage. Under the doctrine of coverture, the husband and wife were one person in the eyes of the law, and that person was the husband. Because the legal personhood of the wife was effectively erased, there were very few rights to litigate. Law students were taught that marriage was a permanent status, not a contract that could be rescinded. As we move into the mid-19th century, the shift from legislative divorce to judicial divorce began to take root. This is where we see the first inklings of a specialized legal practice. However, the American legal education system, led by figures like Christopher Columbus Langdell at Harvard, was undergoing a revolution of its own. Langdell introduced the case method, which sought to treat law as a science. To Langdell and his contemporaries, the law was a series of logical principles derived from appellate court decisions. Divorce, however, was messy. It was emotional. It was entangled with religious dogma and social morality. For the elite law professors of the late 1800s, domestic relations, as it was then called, was seen as intellectually inferior. It was considered a soft subject, lacking the rigorous, predictable logic found in commercial law. Case studies from this era show that many top-tier law schools relegated domestic relations to a single, brief course, or ignored it entirely, leaving the practice to be learned on the fly by lawyers who could not find work in more reputable fields. This educational vacuum led to the rise of the divorce colonies and the infamous divorce mills of the late 19th century. In states like South Dakota and later Nevada, residency requirements were short, and grounds for divorce were more lenient. Lawyers in these regions began to specialize in what we would now call divorce tourism. This period provides a fascinating historical trend. As formal legal education ignored the needs of a changing society, a shadow legal education emerged. These frontier lawyers became experts in jurisdictional maneuvering and the strategic use of fault grounds. They were the first true divorce specialists, but they were viewed with intense hostility by the American Bar Association, which was founded in 1878. The ABA's early efforts were focused heavily on cleaning up the profession, which often meant targeting these divorce lawyers for unethical solicitation and for bringing the law into disrepute. The educational turning point began to manifest in the early 20th century with the rise of sociological jurisprudence. Thinkers like Roscoe Pound began to argue that the law should be judged by its social effects rather than its internal logic. This shift slowly forced law schools to acknowledge that the dissolution of the family was a social reality that required sophisticated legal management. However, the divorce lawyer still faced a steep climb toward respectability. In the 1920s and 30s, legal education started to incorporate more psychology and sociology into the study of domestic relations, but the adversarial nature of the system was already baked in. Because law schools taught divorce through the lens of fault, meaning one party had to be proven guilty of adultery, cruelty, or desertion, the curriculum inherently trained lawyers to be combatants rather than mediators. By examining historical trends in law school textbooks from the 1940s, we see a slow expansion of the curriculum to include the financial aspects of divorce, such as alimony and property division. This was the era where the divorce lawyer began to transform into a financial litigator. The complexity of the tax code and the growth of the middle class meant that there was more at stake than just the end of a personal relationship. There was a literal estate to be carved up. Yet the stigma remained. It wasn't until the no-fault revolution of the 1960s and 70s, spearheaded by the California Family Law Act of 1969, that American legal education was forced to completely rewrite its approach. This history matters to you today because the adversarial ghost of the 19th century fault system still haunts every family court in the United States. Even though we have moved to no-fault systems, the legal education that produces today's lawyers is still rooted in that original transition from scientific commercial law to sociological family law. In this deep dive, we are going to look at the specific case studies of how the first family law clinics were established in the 1970s and how they fundamentally changed the way lawyers are trained to handle your most private moments. We will explore the step-by-step professionalization of the bar, the creation of the American Academy of Matrimonial Lawyers, and how the shyster of the 19th century became the high-stakes litigator of the 21st. We are peeling back the curtain on why your lawyer thinks the way they do. And it all starts with the fact that for 100 years, the smartest people in the legal world tried to pretend that divorce didn't exist. Let's look at the data, the scandals, and the monumental shifts in American pedagogy that created the modern divorce industry. To understand the deep-seated resistance within the American Legal Academy, we have to look at the rigid hierarchy of the early 20th century. If you were a law student in 1926, perhaps a young man named Arthur attending an elite institution on the East Coast, your curriculum was a fortress of commercial predictability. You spent your days dissecting the nuances of maritime insurance and the specificities of trust indentures. In your mind, and in the minds of your professors, the law was a grand architecture of logic. It was clean. It was mathematical. Divorce, on the other hand, was seen as the basement of the legal profession. It was where the logic broke down and the messy, unpredictable elements of human emotion took over. Because of this, the historical study of the divorce lawyer in this era is actually a study of systematic academic avoidance. The elite law schools of the time followed the Langdellian philosophy that law was a science. Under this model, students were taught to look only at the written decisions of high courts to find universal truths. However, divorce cases rarely made it to high courts with intellectual puzzles attached. They were usually factual disputes about who hit whom or who was seen entering a boarding house with a stranger. Professors argued that there was nothing to teach because there was no science to a broken home. This created a massive intellectual vacuum that defined the historical trends of the era. While the public demand for legal separation was rising as the United States transitioned from an agrarian society to an urban one, the premier training grounds for lawyers were essentially pretending the problem did not exist. This meant that the men and women who eventually went into family law were often self-taught or learned through a precarious system of trial and error in the lower courts. Imagine if you were Arthur in 1926 and a neighbor approached you for help with a failing marriage. Your textbook, likely a version of James Schiller's treatise on the law of domestic relations, would have given you a very grim outlook. It would have told you that marriage is a permanent status which the state has a vested interest in preserving. You would have been taught the doctrine of the state as a third party, meaning that a husband and wife could not simply agree to end their marriage. They had to prove to the state that a grievous wrong had been committed. This created a paradoxical legal education where students were taught that the law should prevent divorce, even as the society around them was increasingly seeking it. This mismatch between the classroom and the street led to the rise of what were known as the police court lawyers. These were individuals who operated out of small offices near the city jails and municipal courts. They weren't Harvard or Yale graduates. They were often graduates of the era's night schools or office-trained apprentices. Because they were willing to touch the filth of domestic life, the academic establishment labeled them as shysters. This stigma was not just social, it was reinforced by the curriculum. By refusing to teach the mechanics of divorce, law schools ensured that only those willing to operate on the fringes of professional respectability would take the cases. We see a fascinating case study in the 1906 Supreme Court case of Haddock versus Haddock. This was one of the few domestic cases that actually forced its way into the legal curriculum, and it did so by being an absolute nightmare of jurisdictional confusion. The case involved a husband who moved to Connecticut, got a divorce, and then moved back to New York, only for the New York courts to decide that his Connecticut divorce was worthless. For decades, law students were taught Haddock not to understand the human element of divorce, but as a lesson in the conflict of laws. They were taught how to use the technicalities of state borders to trap or release clients, but they were never taught how to manage the actual dissolution of a family unit. This technical obsession meant that the early American divorce lawyer was being trained as a procedural sniper, looking for ways to exploit the messy patchwork of state laws, rather than as a counselor or an advocate for a fair resolution. As the 1930s approached, this lack of formal education led to one of the most ethically questionable periods in American legal history, the era of the collusive divorce. Because the law schools only taught the fault system, where you had to prove adultery, cruelty, or desertion, and because the state made it nearly impossible to win these cases without a fight, lawyers began to script the drama. In historical trends across major cities like New York and Chicago, we see a rise in the use of professional correspondents. These were people, often young women, hired by the lawyer to be caught in a hotel room in a state of undress with the husband while a photographer burst in. This was a staged scene designed to provide the evidence of adultery, required by the statutes that the law students were studying in their ivory towers. The irony is that while the professors were lecturing on the sanctity of the marital contract, the lawyers in the field were essentially becoming directors of low-budget legal theater. The legal education system's failure to provide a realistic path for divorce created a culture of perjury. A case study from 1934 in New York revealed that in some jurisdictions, over 90% of divorce cases were essentially uncontested, yet the lawyers had to go through the motions of a fake trial. Students were entering the profession completely unprepared for this reality. They were taught the theory of the law in school, and then immediately forced to participate in a system of systemic lying once they entered practice. This created a massive psychological rift in the profession. You had the elite lawyers doing corporate work who looked down on the divorce lawyers, and the divorce lawyers who viewed the elite as out-of-touch academics who didn't understand how the real world functioned. This period also saw the rise of the divorce colonies, which is a critical chapter in the history of the American divorce lawyer. Places like Reno, Nevada, and Sioux Falls, South Dakota, realized that if the elite law schools weren't going to teach lawyers how to handle divorce, they would create a business environment that made it easy. They lowered residency requirements to just a few weeks. Lawyers in these towns became the most specialized divorce practitioners in the country. They weren't scholars of the law in the traditional sense. They were experts in the logistics of the quick exit. This forced the legal academy into a defensive crouch. Instead of evolving the curriculum to meet the demand, many state bar associations, populated by the graduates of those elite schools, tried to pass laws making it illegal for lawyers to advertise their services in these colonies. It was a war between a stagnant educational model and a rapidly changing social reality. Step by step, the pressure began to mount. The data from the post-depression era showed that even as the economy struggled, the demand for marital dissolution remained steady. People were willing to spend their last dollars to escape a bad marriage. This financial reality eventually began to catch the eye of the more pragmatic law schools. They started to realize that if they didn't start teaching domestic relations seriously, they were ceding a massive and profitable portion of the legal market to the unranked night schools. We began to see the very first ripples of change in the late 1940s, as the aftermath of World War II brought home millions of soldiers whose marriages had collapsed under the strain of the conflict. The legal education system could no longer ignore the millions of veterans who needed these services. But as the academy finally began to open its doors to the study of divorce, a new and even more controversial element was about to be introduced. It wasn't just about the law anymore, it was about the mind. The next great shift would involve bringing the psychiatrist into the classroom, a move that many traditionalists feared would destroy the science of law forever. If the law was no longer a set of rigid rules, but a tool for social engineering and psychological healing, then what would happen to the role of the lawyer? We are about to look at the explosive entry of the behavioral sciences into the law school curriculum, and how it turned the divorce lawyer into something far more powerful and far more dangerous than a simple procedural sniper. In the next part, we will uncover how the 1950s therapeutic model set the stage for the modern high-conflict litigation we see in 2026. What happens when a lawyer is taught to be a therapist without a license? The answer changed the American courtroom forever. As we move into the 1950s, the American law school classroom underwent a silent but seismic shift that would forever change the profile of the divorce lawyer. To understand this, imagine a law student in 1955 named Sarah. She is attending a top-tier university, and for the first time in the history of her institution, the domestic relations course is being taught not by a dusty property law professor, but by a team that includes a visiting sociologist. This was the birth of the interdisciplinary approach, a movement that sought to ground legal principles in the burgeoning fields of psychology and behavioral science. In this decade, the legal academy began to realize that the rigid, rule-based approach of the previous century was failing to address the complexities of modern American life. They were no longer just training procedural snipers, they were beginning to train what critics at the time called social engineers. This era marked the transition from viewing marriage as a cold, static contract to viewing it as a psychological status. Historical trends from the mid-20th century show a significant increase in law school seminars that focused on the root causes of marital instability. Sarah and her classmates were no longer just memorizing the statutes for adultery or extreme cruelty. Instead, they were being asked to analyze the domestic ecosystem. They were reading case studies that integrated psychiatric evaluations of the parties involved. This shift was fueled by the realization that if the law were to maintain its relevance, it had to account for the human mind. Consequently, the curriculum began to emphasize the role of the lawyer as a counselor. This was the moment the divorce lawyer was taught to step out of the courtroom and into the office as a quasi-therapist, a role that remains a central, albeit controversial, pillar of the profession in 2026. A pivotal case study in this educational evolution was the work being done at Yale Law School under the influence of professors like Fowler Harper. Harper was a pioneer who argued that the law of domestic relations should be an instrument of social welfare. He pushed for a curriculum that ignored the technicalities of fault and instead looked at the functional reality of the family. Under this new pedagogical model, law students were taught to evaluate the best interests of the child, a phrase that was just beginning to gain its modern, potent legal weight. Before this, custody was often treated as a property right, usually favoring the father as the economic head of the household, or the mother under the tender years doctrine, which assumed younger children needed maternal care. But the new 1950s curriculum taught students to look at psychological attachment. They were taught to interview child psychologists and to use clinical data to argue for specific custodial arrangements. This was a radical expansion of the lawyer's toolkit. It required a student to be as proficient in reading a personality profile as they were in reading a brief. Step by step, the traditional adversarial model began to crack. The legal education system started introducing the concept of the family court, a specialized venue that would prioritize reconciliation and social services over punishment and judgment. Students were trained to navigate these new informal settings, which were designed to feel less like a battle and more like a clinic. However, this created a massive professional tension. On one hand, the law schools were teaching students to be empathetic and focused on the psychological health of the family. On the other hand, the actual statutes on the books in almost every state still required one party to prove the other was a villain. This mismatch between educational theory and legal reality forced the 1950s divorce lawyer into a position of extreme ethical flexibility. They were being trained as healers in the classroom, but they were being paid as gladiators in the courtroom. The data from this period reflects a growing professionalization of the matrimonial bar. We see the first major push for specialized certification. The historical study of the divorce lawyer shows that by the late 1950s, the American Bar Association began to see the need for a section of family law, which was eventually established in 1958. This was a landmark moment for legal education because it provided a formal structure for the development of standardized teaching materials. It moved the subject from the periphery to a recognized specialty. However, this professionalization came with a hidden cost. By teaching lawyers to be experts in the psychological and social aspects of divorce, the law schools were inadvertently creating a system that could be used to pathologize the opposition. Imagine if Sarah, now a practicing attorney in the early 1960s, used her training to secure a potential outcome for a client. Instead of just proving a husband was unfaithful, she could now use the language of her legal education to argue that he was psychologically unfit, using terms like narcissism or emotional instability that she had first encountered in her law school seminars. This introduced a new level of high-stakes conflict into divorce litigation. The legal education system had provided the weapons of behavioral science to a profession that was still fundamentally adversarial. This is why, in 2026, we see divorce cases that devolve into multi-year battles over psychiatric evaluations and parental fitness. The seeds of this high-conflict environment were planted in the well-intentioned classrooms of the 1950s. Furthermore, the study of the financial aspects of divorce became significantly more sophisticated during this time. Law schools began to integrate complex tax theory and future earnings projections into their domestic relations courses. The divorce lawyer was no longer just dividing the house and the car. They were being taught to view a spouse's career path as a marital asset. This was a crucial historical trend that prefigured the massive alimony and equitable distribution battles of the late 20th century. Students were taught to calculate the present value of a professional degree or a corporate pension. This required a level of mathematical and economic literacy that had previously been reserved for corporate lawyers. The divorce lawyer was becoming a hybrid professional, part psychologist, part accountant, and part trial attorney. This deep dive into the 1950s and early 60s reveals a paradox. The more the legal education system tried to make divorce more humane by introducing social science, the more complex and expensive the process became. By expanding the scope of what was relevant in a divorce case, from simple fault to complex psychological and economic data, the law schools created a need for more hours of legal work, more expert witnesses, and more sophisticated litigation strategies. The educational shift intended to help families was also the catalyst for the multi-billion-dollar industry that characterizes family law today. We have now reached the brink of the most explosive change in the history of the American legal system. While the law schools were busy integrating psychology, a social revolution was brewing that would render the entire concept of fault obsolete. The 1960s were about to challenge every pedagogical assumption about marriage and state control. But what happens to a profession when the very foundation of its practice, the proof of wrongdoing, is suddenly removed by the legislature? How does a lawyer, trained in the art of the psychological attack, survive in a world where you can get a divorce simply because you want one? In the next part, we will explore the chaotic birth of the no-fault revolution and how it forced law schools to completely reinvent the divorce lawyer for a new liberated America. The transition was not as smooth as the history books suggest, and it involved a secret battle between the legal academy and the practicing bar that almost destroyed the profession. We are going into the heart of the 1969 California Revolution. The transition into the no-fault era was not a gradual evolution but a sudden, jarring break with centuries of legal tradition. When Governor Ronald Reagan signed the California Family Law Act of 1969, he effectively dismantled the moral architecture that had governed American domestic relations since the colonial era. For the legal academy, this was an existential crisis. To understand the magnitude of this shift, imagine a law student in 1970 named Michael. Michael had entered law school expecting to learn the art of the cross-examination in the context of moral failing. He had spent his first year studying the classic fault grounds: adultery, extreme cruelty, and willful desertion. He was prepared to be a detective as much as a lawyer, learning how to present evidence of a secret life or a broken vow. But as he sat in his family law seminar in the fall of 1970, the professor likely began the class by telling him that everything he had memorized about the guilt of the parties was now legally irrelevant. This change in legislation forced an immediate and radical redesign of the legal curriculum. Historical trends show that prior to 1969, the study of divorce was essentially the study of torts within the bedroom. Law schools focused on the elements of proof required to secure a decree. After 1969, the focus shifted from the why of the divorce to the what of the dissolution. The very terminology changed in the classroom. Students were no longer taught to seek a divorce. They were taught to manage a dissolution of marriage. This wasn't just a linguistic preference. It was a fundamental shift in how the law viewed the family. Under the new no-fault pedagogy, marriage was increasingly treated like a business partnership that could be terminated by either partner at will. This required a completely different set of skills from the emerging divorce lawyer. The curriculum had to pivot toward the complex mechanics of community property and equitable distribution. Before the no-fault revolution, the division of property was often used as a punishment for the guilty party or a reward for the innocent one. In the new era, law schools began to emphasize the mathematical and economic aspects of the split. Case studies from this period at schools like UCLA and UC Berkeley show a surge in courses focused on the valuation of marital assets. Students like Michael were now tasked with understanding the tax consequences of transferring a family residence or the actuarial complexities of dividing a state pension. The divorce lawyer was being rebranded in the classroom as a sophisticated financial auditor. This was a direct response to the legislative removal of fault. If the lawyer could no longer win by proving their client was a saint, they had to win by proving their client was entitled to a larger share of the economic pie. However, this transition met with fierce resistance from the practicing bar. While the legal academy, driven by liberal sociological theories, embraced the idea of a less acrimonious administrative process, the lawyers in the field were terrified. They believed that no-fault divorce would lead to the commoditization of their profession. If a couple could simply file a paper stating that irreconcilable differences existed, why would they need to pay a high-priced attorney thousands of dollars? This fear led to a fascinating conflict between the law schools and the professional associations. The practicing bar lobbied for the retention of complex procedural hurdles, while the academy pushed for simplified, no-fault codes like the Uniform Marriage and Divorce Act. To counter the threat of obsolescence, the legal education system did something brilliant and arguably devastating for the future of the American family. It made the financial and custodial side of the law so incredibly complex that the need for a lawyer actually increased. Step by step, the simple no-fault concept was layered with intricate new doctrines. Law schools began teaching students about the concept of the professional degree as a marital asset. A landmark case study taught in almost every classroom in the 1970s was O'Brien v. O'Brien, where a court ruled that a husband's medical license was a property interest subject to distribution. This single legal theory, birthed in the hallways of academia, ensured that divorce would remain a high-stakes, expert-driven enterprise. Students were now required to learn how to hire and depose vocational experts, forensic accountants, and business appraisers. The no-fault revolution, which was intended to simplify divorce, inadvertently created a new, more expensive battlefield of expert testimony. Furthermore, the study of child custody underwent a radical transformation in the wake of 1969. With the removal of fault, the old presumptions that favored the innocent party were gone. In their place, the academy solidified the best interests of the child standard. This sounds noble in theory, but in the classroom, it was taught as an open-ended invitation for litigation. Law students were trained to use psychological evaluations as tactical weapons. They learned how to navigate the emerging field of joint custody, which became a standard part of the curriculum by the late 1970s. This required a student to understand not just the law, but developmental psychology and family dynamics. The divorce lawyer was being educated to act as a coordinator of a multidisciplinary team, managing psychologists, social workers, and guardians ad litem. The data from the 1970s shows a massive spike in divorce rates as the no-fault laws spread across the United States. This created an unprecedented demand for legal services, and law schools responded by expanding their family law departments. What was once a single elective course became a suite of specialized offerings: family wealth management, child advocacy, and domestic violence law. This specialization helped to finally shed the shyster image of the divorce lawyer. By turning the practice into a high-level academic discipline involving complex economics and social science, the academy provided the profession with the prestige it had lacked for a century. The divorce lawyer was no longer a bottom feeder. They were a necessary architect of social reorganization. But there was a darker side to this educational shift. By removing the moral gatekeeping function of the law, the academy and the legislature essentially privatized the conflict. When the state stopped caring about why a marriage ended, it left the parties to fight over every other detail with a new level of ferocity. The law student of 1975 was being taught that there was no such thing as a wrong reason to leave, but there were many wrong ways to divide the bank account. This created a culture of procedural warfare. The curriculum began to focus heavily on discovery, the process of forcing the other side to hand over every document, every email, and every financial record. Students were taught that information was power, and the aggressive pursuit of that information became the hallmark of the modern divorce practitioner. As we look at the historical trends that emerged from this era, we see the beginning of the legal arms race. If one side hired a lawyer trained in the new, sophisticated financial tactics of the 1970s academy, the other side had no choice but to do the same. This led to a dramatic increase in the cost of divorce, even as the legal grounds became simpler. The 1969 revolution didn't end the conflict. It just changed the currency of the battle from morality to money and psychological dominance. By the time we reached the 1980s, the divorce lawyer had become one of the most powerful and feared figures in the American legal landscape, backed by an educational system that had provided them with an arsenal of interdisciplinary tools. But as the financial stakes reached an all-time high, a new question began to haunt the law school classrooms. If the goal of the no-fault revolution was to reduce hostility, why were the courthouses more crowded than ever? Why were families being bankrupt by the very process designed to liberate them? The legal academy was about to face a reckoning. In the next part, we will examine the rise of the alternative dispute resolution movement in the 1980s. We will see how law schools, realizing they had created a monster of high-conflict litigation, tried to pivot once again, this time toward mediation and collaborative law. But could a profession trained for a century in the art of war ever truly learn the art of peace? We are going to look at the secret history of why mediation often fails, and how the divorce lawyer of the 1980s learned to co-opt the peace movement to maintain their grip on the industry. The evolution from gladiator to mediator was not what it seemed. By the early 1980s, the American legal education system faced a crisis of its own making. The no-fault revolution, while simplifying the legal grounds for ending a marriage, had inadvertently created a vacuum that was filled by hyper-complex financial litigation and psychological warfare. Law school graduates were entering a field where court dockets were so congested that a simple custody hearing could be delayed for 18 months. The public was growing resentful of the legal fees that often consumed the very marital assets being contested. To understand how the academy responded, imagine a law student in 1984 named David. David is attending a prestigious law school where the walls are lined with portraits of legendary trial lawyers. He is being trained in the art of the deposition and the mechanics of the subpoena. But in his third year, he is required to take a brand new course that represents a radical departure from everything he has learned: alternative dispute resolution, or ADR. This was the birth of the mediation movement within the American legal curriculum. Historical trends from this period show a growing realization among elite educators that the adversarial system was breaking under its own weight. Chief Justice Warren Burger famously remarked in 1984 that our system is too costly, too painful, too destructive, and too inefficient for a truly civilized people. This sentiment became the North Star for a new generation of legal scholars. At Harvard, the program on negotiation was established, and the book Getting to Yes by Roger Fisher and William Ury became the unofficial Bible for a new kind of divorce lawyer. David and his classmates were no longer just taught to fight for a bigger slice of the pie. They were being taught the theory of interest-based bargaining. They were instructed to look past the legal positions, "I want the house," to the underlying interests, "I want stability for my children." Step by step, the law school curriculum began to deconstruct the gladiator model. In these new ADR seminars, students were put through role-playing exercises that would have been unthinkable a decade earlier. David would spend his Tuesday afternoons acting as a neutral mediator, sitting between two classmates who were pretending to be a warring husband and wife. He was graded not on his ability to crush an opponent under cross-examination, but on his ability to facilitate communication and find a win-win potential outcome. This was a profound shift in the historical study of the divorce lawyer. The academy was trying to rebrand the lawyer as a peacemaker. They argued that because divorce was a continuing relationship, especially when children were involved, the scorched earth tactics of the 1970s were actually a form of legal malpractice. A critical case study from this era is the 1981 publication of the article Bargaining in the Shadow of the Law by Robert Nooken and Louis Kornhauser. This piece of scholarship changed everything in the classroom. It argued that the primary role of the divorce lawyer was not to go to trial, but to negotiate a settlement that reflected what a judge might do if they actually went to court. The shadow of the law meant that the legal system provided the backdrop and the constraints, but the actual resolution happened in the lawyer's office. Law students were now being taught that the courtroom was a sign of failure, and that the true master of family law was the one who could keep their clients out of it. This theory provided the intellectual foundation for the modern divorce practice we see in 2026, where over 95% of cases are settled before trial. However, as the 1980s progressed, a fascinating and somewhat cynical trend emerged: the co-option of the peace movement by the legal profession. While the law schools were teaching David how to be a healer, the practicing bar was figuring out how to turn mediation into a new profit center. If mediation was going to be the future, then lawyers ensured they would be the ones to run it. Law schools began offering specialized certificates in mediation, ensuring that only those with a Juris Doctor could claim the highest level of expertise. They didn't just teach students how to mediate, they taught them how to use mediation as a strategic tool within the broader litigation process. Imagine if David, now a young associate in 1986, used his law school training to suggest mediation to the opposing side, not because he wanted peace, but because he wanted a free look at the other side's evidence. In the classroom, mediation was taught as a transparent and collaborative process. In the field, it was often used as a low-cost discovery tool. This mismatch created a new kind of hybrid professional, the litigation-aware mediator. The legal education system had successfully pivoted, but it hadn't necessarily removed the conflict. It had simply moved the conflict from the public courtroom to the private conference room. This transition allowed the divorce lawyer to maintain their professional prestige and their billing rates while appearing to be part of the solution rather than the problem. Data from the late 1980s reveals a surge in mandatory mediation laws across the United States. States like California and Florida began requiring parents to meet with a mediator before they could even step foot in front of a judge. This created a massive new market for the graduates of these ADR-focused law programs. The divorce lawyer was no longer just an advocate. They were now being trained as a gatekeeper to the judicial system. Students were taught how to prepare their clients for mediation, which often meant teaching them how to be strategically reasonable. They learned how to draft complex settlement agreements that were so technically dense they required hours of legal review, ensuring that even in a peaceful resolution, the lawyer's role remained indispensable. The 1980s also saw the introduction of the collaborative law movement, which was first conceptualized by a lawyer named Stuart Webb. Collaborative law took the Academy's ADR theories to their logical extreme. Both lawyers and their clients sign a contract agreeing that if they can't settle and have to go to court, the lawyers must withdraw and the clients must start over with new counsel. This was a radical educational experiment. It forced the lawyer to be 100% committed to settlement because their own financial interest was tied to it. Law schools began incorporating collaborative law clinics into their curriculum, teaching students a revolutionary concept: that sometimes the best way to represent a client is to take the threat of litigation off the table entirely. Yet, as we look deeper into the historical trends of this era, we see that the rise of the peacemaker lawyer didn't actually lower the cost of divorce for the average American. Instead, it created a two-tiered system. The elite, trained in the sophisticated negotiation techniques of the top law schools, were practicing high-end ADR for wealthy clients. Meanwhile, the lower end of the market was still dominated by the high-conflict, high-volume practitioners who relied on the old adversarial methods. The legal education system had created a new elite tier of divorce practice, but it hadn't solved the systemic issues of accessibility and affordability. We have reached a point in our study where the divorce lawyer has become a master of both war and peace. They are accountants, psychologists, and now expert negotiators. But as the 1980s drew to a close, a new and darker force began to emerge in the legal landscape. The rise of the private judge and the total commoditization of the child would challenge the limits of the ADR movement. What happens when the peace process itself becomes a luxury product? How did the law school curriculum of the 1990s respond when the very children they were trying to protect became the center of a new high-tech surveillance economy? In the next part, we will explore the era of the high-asset divorce wars and the rise of the private judiciary. We will see how the divorce lawyer of the 1990s learned to bypass the public courts altogether, creating a secret system of justice for the American elite. The peaceful mediation of the 80s was about to be replaced by the ruthless efficiency of the private courtroom. As we enter the 1990s, the American legal landscape was being reshaped by an unprecedented surge in private wealth, particularly within the tech and financial sectors. This era demanded a new kind of practitioner, and the legal education system responded by moving away from the touchy-feely mediation of the 1980s toward a model of high-stakes corporate-style litigation. To understand this transition, imagine a law student in 1994 named Jennifer. Jennifer is attending a top-tier law school in California or New York. In her family law seminars, the discussion is no longer just about psychological attachment or interest-based bargaining. Instead, she is being taught how to read a balance sheet for a multinational corporation and how to value stock options that haven't even vested yet. This was the birth of the forensic divorce era, a time when the divorce lawyer was reimagined as a financial detective. Historical trends from the 1990s show that as the wealth gap in the United States began to widen, the Legal Academy realized that the standard domestic relations curriculum was woefully inadequate for the elite. The response was the introduction of complex courses in advanced tax theory, business valuation, and the hidden mechanics of offshore trusts. Jennifer and her classmates were being prepared to represent the new American aristocracy, the Silicon Valley founders and the Wall Street hedge fund managers. For these clients, a public trial was not just an inconvenience. It was a catastrophic risk to their brand and their stock price. This led to one of the most significant and least discussed shifts in the history of the American divorce lawyer: the rise of the private judiciary. The curriculum in Jennifer's law school began to focus heavily on the concept of the rent-a-judge. In states like California, statutory provisions allowed parties to hire a retired judge to hear their case in a private setting. This wasn't mediation. This was a full-scale trial conducted in a high-end law firm's conference room, away from the prying eyes of the public and the media. Law schools began teaching students the strategic advantages of forum selection. They weren't just learning how to litigate, they were learning how to buy a specialized justice system. This created a two-tiered educational track. While the general curriculum still covered the basic no-fault principles for the masses, an elite track was emerging that taught the art of the secret divorce. This involved learning the step-by-step process of drafting confidentiality agreements that were so ironclad they could survive even the most aggressive investigative journalism. A critical case study from this period that dominated law school classrooms was the ongoing fallout from the 1976 Marvin versus Marvin case, which had established the concept of palimony. By the 1990s, the Academy had taken the principles of Marvin and expanded them into a complex web of contract law and equitable claims. Students like Jennifer were taught to look at every cohabiting relationship as a potential legal landmine. They were trained to draft prenuptial and postnuptial agreements that were no longer just simple documents, but massive hundreds of pages long contracts that attempted to predict every possible financial potential outcome of a marriage. The divorce lawyer was becoming a transactional architect, building legal fortifications years before a relationship even began to fail. The 1990s also marked the beginning of the digital revolution in the courtroom, and the legal education system had to pivot quickly to address the emerging field of electronic discovery. Imagine Jennifer in a clinic in 1996, learning for the first time how to subpoena a hard drive or how to recover deleted emails. This was a radical departure from the paper-based evidence of the past. Law schools began partnering with tech experts to teach students the forensic art of the digital trail. They learned how to use metadata to prove where a spouse had been or what they had been buying. This shift turned the divorce lawyer into a digital surveillance specialist. The historical study of the divorce lawyer shows that this was the moment the profession became truly intrusive. The Academy provided the theoretical framework for using a client's digital life as a weapon, a practice that has only intensified in 2026 with the advent of AI-driven surveillance tools. Furthermore, the study of child custody in the 1990s moved away from the simple best interest standard toward a more data-driven clinical approach. Law schools began to emphasize the role of the parental alienation expert. This was a highly controversial and influential development. Students were taught that a child's preference could be manufactured or manipulated by a parent, and they were trained to use psychological experts to debunk a child's own testimony. This introduced a new layer of complexity and expense to custody battles. A case study often used in Jennifer's classes involved the high-conflict litigation of the era, where psychologists would spend hundreds of hours observing family interactions, producing reports that cost tens of thousands of dollars. The divorce lawyer was taught to be the manager of these experts, synthesizing complex psychiatric data into a legal narrative that could convince a private judge. Data from the late 90s reflects a massive professionalization of these subspecialties. Organizations like the American Academy of Matrimonial Lawyers began to exert significant influence over what was taught in law schools, pushing for higher standards of financial and technical literacy. This wasn't just about prestige, it was about market control. By making the practice of family law so intellectually and technically demanding, the elite practitioners ensured that they could charge rates that rivaled the top corporate firms in the world. The divorce lawyer had finally achieved the status they had sought for a century, but they had done so by creating a system that was increasingly inaccessible to the average person. This period also saw the rise of the collaborative law movement as a direct reaction to the excesses of the 1990s litigator. While Jennifer was learning how to be a digital sniper, other students were being taught how to dismantle the adversarial framework entirely. However, the academy struggled with this tension. How do you teach a student to be both a ruthless financial auditor and a collaborative peacemaker? This pedagogical split created a fractured profession. We began to see the emergence of boutique family law firms that specialized in only one approach, either scorched earth litigation or high-end collaborative settlement. This specialization is a key historical trend that defines the modern landscape in 2026. As we look at the evolution during this decade, we see that the divorce lawyer had become a master of the private sphere. They had learned how to use the law to create a secret world of justice for those who could afford it. They had integrated finance, psychology, and technology into a single potent discipline. But as the millennium approached, a new set of challenges was on the horizon. The internet was about to change the way people met, the way they hid assets, and the way they fought. The legal education system was about to be hit by a wave of globalization that would force the divorce lawyer to look beyond the borders of the United States. What happens when a marriage is formed in New York, the assets are in a shell company in the Cayman Islands, and the children are being held in London? How does a law school in 2026 prepare a student for a world where the very concept of a home state is becoming obsolete? In the next part, we will explore the rise of the international divorce lawyer and the Hague Convention. We will see how the Academy responded to the era of the global family and the new terrifying reality of international parental abduction. The divorce lawyer was about to become a diplomat in a world where the borders were disappearing, and the stakes were higher than ever before. We are moving into the era of the transcontinental legal war. The transition into the early 2000s and the lead up to our current year of 2026 marked the era of the globalized divorce, a period that forced American legal education to look far beyond the boundaries of state lines and even federal borders. To visualize this shift, imagine a law student in 2008 named Christopher. Christopher is sitting in a lecture hall at a major urban university, but the map on the projector is not of the United States. It is a complex web of jurisdictions including the European Union, the United Arab Emirates, and various offshore financial centers in the Caribbean. Christopher is not just learning the basics of the no-fault system. He is being trained in the high-stakes world of private international law. This was the moment the divorce lawyer became a geopolitical strategist. Historical trends during this period show that as international travel and digital communication became ubiquitous, the number of transnational marriages skyrocketed. This created a massive problem for the legal academy. The traditional domestic relations curriculum was designed for a world where people stayed in their hometowns. If a couple married in New York, moved to Hong Kong for work, and then separated while one spouse was visiting family in London, which court had the right to decide their fate? Law schools had to rapidly integrate a complex field, known as the conflict of laws, into their family law departments. Christopher and his classmates were taught the step-by-step mechanics of the race to the courthouse. In this globalized environment, the first person to file in a favorable jurisdiction could determine the financial potential outcomes of the entire case. Students were taught to analyze the laws of different countries to find the most advantageous forum for their future clients, a practice known as forum shopping. A critical pillar of this new international curriculum was the 1980 Hague Convention on the civil aspects of international child abduction. While the treaty had been around for decades, it was only in the 2000s that it became a mandatory part of any serious family law education. Christopher spent weeks dissecting the concept of habitual residence. This is a term of art that law students must master with precision. It doesn't mean where a child is a citizen. It means where the child has established a center of gravity in their life. Case studies from this era often involved a parent taking a child on a vacation to their home country and then refusing to return. Law schools began teaching students how to litigate these cases in federal court, which was a significant change. Previously, divorce lawyers stayed in state-level family courts. Now they were being educated to handle high-level federal litigation, involving international treaties and diplomatic communication. Step by step, the curriculum expanded to include the Hague Service Convention and the Hague Evidence Convention. Imagine Christopher learning the grueling process of serving legal papers on a spouse living in a country that does not recognize American subpoenas. He had to learn how to work with central authorities in foreign governments and how to hire local counsel in places like Singapore or Switzerland. This required a level of cultural competency and administrative patience that had never been part of the divorce lawyer's training before. The academy was essentially creating a class of lawyers who functioned like diplomats, navigating the tensions between different legal systems and traditions. The financial aspect of the international divorce was even more complex. By the mid-2010s, and certainly by 2026, the historical study of the divorce lawyer must account for the rise of global asset concealment. Law schools began offering advanced seminars on the Foreign Account Tax Compliance Act, or FATCA. Students were taught how the United States government began requiring foreign financial institutions to report on assets held by American citizens. This changed the way discovery was conducted. Christopher was no longer just looking at local bank statements. He was learning how to trace money through layers of international shell companies and trust structures designed specifically to shield wealth from the reach of the family court. This era saw the introduction of international forensic accountants as guest lecturers in law school classrooms, teaching students how to spot the subtle signs of offshore capital flight. As we look at the data leading into 2026, we see that the emergence of cryptocurrency added a final, dizzying layer to this education. Law students today are taught the basics of blockchain analysis as a standard part of their family law training. They are learning how to use digital subpoenas to track wallets that have no physical location and no traditional bank to verify them. The divorce lawyer of 2026 is part computer scientist, part international investigator. The Academy has responded by creating interdisciplinary clinics where law students work alongside cybersecurity experts to recover hidden digital assets. This represents the total evolution of the profession. The lawyer who once only needed to know the local statutes now needs to understand the global flow of decentralized finance. Another major shift in the historical trends of the 2010s was the study of the transnational prenuptial agreement. Law schools began teaching students how to draft contracts that would be enforceable in multiple countries simultaneously. Imagine Christopher trying to draft a document that satisfies the rigid contract requirements of New York, while also adhering to the more traditional family law principles of a civil law country like France. This required an education in comparative law, looking at the differences between common law and civil law systems. Students were taught that a clause that works in Chicago might be considered a violation of public policy in Tokyo. This level of granular, global detail became the hallmark of the elite divorce practitioner. This internationalization also brought a new focus on human rights into the classroom. Law schools began to look at how international law protects women and children in jurisdictions where domestic laws might be discriminatory. Students were taught to use international human rights treaties as persuasive authority in domestic cases. This added a layer of moral and ethical complexity to the curriculum. The divorce lawyer was no longer just a facilitator of a private split. They were often seen as the last line of defense for a client facing the loss of their children or their economic survival across international lines. But as the 2020s progressed, a new domestic revolution was also happening that would fundamentally challenge the very definition of the family unit. While Christopher was mastering the Hague Convention, the Legal Academy was also grappling with the fallout of the same-sex marriage movement and the emergence of non-traditional family structures. This was not just a social change, it was an educational earthquake. Every textbook had to be rewritten. Every precedent had to be re-examined. The legal education system was about to enter its most inclusive and most legally complex chapter yet. What happens to the divorce lawyer when the law finally recognizes that there is no single template for a family? How does the academy train a student to navigate the dissolution of a relationship that the law didn't even recognize a decade ago? In the next part, we will explore the impact of Obergefell versus Hodges on the family law curriculum and the rise of the LGBTQ+ divorce specialty. We will see how the legal education system had to catch up with a rapidly changing social reality that redefined everything from parentage to property. We are entering the era of the modern inclusive dissolution, where the old rules of gender and status were finally stripped away, leaving a whole new set of legal puzzles in their place. The classroom was about to become a laboratory for a new kind of social justice. The classroom was about to become a laboratory for a new kind of social justice. Immediately following the 2015 Supreme Court decision in Obergefell versus Hodges, the American legal education system faced a pedagogical overhaul that was as profound as the no-fault revolution of 1969. For over a century, the study of the divorce lawyer was built upon the bedrock of the gendered marital contract. Textbooks were written with a husband and a wife in mind, and the entire body of case law regarding property division and alimony was filtered through a heteronormative lens. To understand the chaos this caused in the ivory tower, imagine a law student in 2016 named Taylor. Taylor is attending a family law seminar where the professor is literally crossing out entire chapters of the textbook. The old definitions of the marital estate and the presumption of paternity are suddenly under immense academic scrutiny. This wasn't just a change in the law. It was a total reconstruction of the legal DNA that divorce lawyers were expected to possess. One of the most complex historical trends to emerge from this era was the problem of retroactive marriage. This became a central case study in law school classrooms throughout the late 2010s and continues to be a staple of advanced family law pedagogy in 2026. Imagine if you are Taylor and you are presented with a case involving a couple, Marcus and Julian. Marcus and Julian lived together in a committed relationship for 30 years in a state that did not recognize their union. They finally married in 2015 and filed for divorce in 2026. Under traditional legal education, Taylor would be taught that the marital estate only began in 2015. This would mean that 30 years of shared assets, retirement contributions, and property appreciation would be classified as separate property, potentially leaving one partner in a position of extreme economic vulnerability. The legal academy had to innovate. Students were now being taught to use equitable theories like quantum merit, constructive trusts, and implied contracts to bridge the gap between decades of domestic partnership and a few years of legal marriage. This required the divorce lawyer to be more than a statutory technician. They had to be an architect of equity, arguing for a sense of fairness that the written law had previously denied. Step by step, the curriculum began to deconstruct the very idea of the nuclear family. Law schools started introducing the Uniform Parentage Act into their core requirements, moving away from the old common law presumption of legitimacy. Historically, the law assumed that if a woman was married, her husband was the legal father of any child born during the marriage. In the post-Obergefell classroom, this presumption had to be reimagined as gender-neutral. Taylor and her classmates were now studying cases where a child might have two legal mothers or two legal fathers, neither of whom had a biological connection to the child. This led to the rise of the de facto parent doctrine in legal education. Students were taught that a person who has lived with a child, provided for their needs, and established a parental bond should have legal standing in a divorce, regardless of biology or formal adoption. This shift turned the divorce lawyer into a specialist in functional parentage, focusing on the psychological reality of the family rather than the biological one. The data from this period shows a significant increase in law school clinics specifically dedicated to LGBTQ+ family law. These clinics became the front lines for testing new legal theories that would eventually become standard practice. For example, students were trained to handle the unique complexities of the second-parent adoption process and how to dismantle those adoptions during a high-conflict divorce. They were also taught how to navigate the messy transition from civil unions and domestic partnerships to marriage. In many jurisdictions, couples had layers of different legal statuses that overlapped and conflicted. The 2026 divorce lawyer is educated to be a forensic historian, untangling these various legal threads to determine the exact start and end points of a couple's financial and legal obligations. Furthermore, the study of assisted reproductive technology became a mandatory part of the divorce lawyer's education. Imagine Taylor in a 2026 seminar discussing the legal status of frozen embryos in a divorce. This is one of the most high-stakes areas of modern family law. Students must study the intersection of contract law and constitutional rights. Is an embryo a person with a right to life, or is it property to be divided like a bank account? Law schools teach students to analyze the intent of the parties at the time the embryos were created. They study case studies where one partner wants to use the embryos to have a child against the wishes of the other. The divorce lawyer is trained to draft and litigate embryo disposition agreements, a task that requires a deep understanding of bioethics and the latest developments in reproductive science. Historical trends also point toward a radical shift in how alimony, or spousal support, is taught. For decades, alimony was based on the idea of a breadwinner husband and a homemaker wife. The legal academy has had to reinvent this entire field to be gender-neutral and based on functional roles rather than traditional expectations. In Taylor's 2026 curriculum, the focus is on the compensatory model of alimony. Students are taught to calculate the economic sacrifice made by one partner to support the career of the other, regardless of gender. This involves sophisticated economic modeling, and the use of vocational experts to determine the earning capacity of a spouse who has been out of the workforce for years. The divorce lawyer has become a specialized economic analyst, capable of presenting a compelling narrative of financial interdependence that justifies a long-term support award. This educational evolution has also led to a new emphasis on the lawyer as an advocate for administrative reform. Students are taught that the very forms and computer systems used by the courts are often outdated and discriminatory. The 2026 divorce lawyer is trained to challenge the institutional inertia of the court system, pushing for gender-neutral filings and more inclusive court procedures. This is a far cry from the 19th century lawyer who was taught to uphold the status quo. Today's academy produces lawyers who are comfortable with the idea that the law is a living, breathing instrument that must adapt to the diversity of American life. As we look deeper into the curriculum of 2026, we see the rise of the multi-parentage case study. Law schools are now exploring the legal implications of polyamorous relationships or co-parenting arrangements involving more than two people. While most states do not yet recognize multi-parentage, the Legal Academy is already preparing students for the eventual dissolution of these complex family units. How do you divide assets among three people? How do you create a three-way custody schedule? By exploring these hypothetical scenarios, the law schools are pushing the boundaries of what is possible, training a generation of lawyers who are ready for a future that is even more legally complex than the present. The transition to an inclusive, modern curriculum has not been without its critics. Some traditionalists argue that by moving away from clear, biological and gendered rules, the Academy has made the law too unpredictable and too expensive to litigate. They point to the fact that every new equitable theory and every new parentage doctrine requires more hours of legal work and more expert testimony. Yet, the data suggests that this complexity is a necessary response to the reality of the 2026 American family. The divorce lawyer is no longer just a legal mechanic, they are a social architect. But as the law becomes more inclusive and specialized, a new and even more powerful force is entering the classroom. It is a force that threatens to automate the very expertise that took a century to build. What happens to the divorce lawyer when an algorithm can divide a marital estate in seconds? How does the legal education system respond when artificial intelligence can predict a judge's ruling on a custody case with 90% accuracy? In the next part, we will explore the impact of the AI revolution on American legal education. We will see how law schools in 2026 are training students to work alongside machine learning, and how the human element of the divorce lawyer is being reevaluated in the age of the algorithm. The battle between the heart and the code is about to begin. As we step into the classroom of 2026, the transition from the library to the cloud is complete. To understand the magnitude of this shift, imagine a law student named Ethan. Ethan is a third-year student at a top-tier American university. He is not surrounded by stacks of leather-bound casebooks like his predecessors in 1926 or even 1996. Instead, his primary tool is a neural-linked legal intelligence interface. When Ethan is assigned a complex marital dissolution case involving 3 different jurisdictions and a portfolio of decentralized assets, he does not spend weeks in the archives. He spends minutes refining a prompt. This is the era of the algorithmic divorce lawyer, and it has forced the American legal education system to undergo its most radical transformation since the introduction of the case method over 150 years ago. Historical trends from the early 2020s show a period of intense anxiety within the legal academy. When generative AI first broke into the mainstream, law professors feared that the very core of legal training, the ability to research and write a persuasive brief, was being rendered obsolete. However, by 2026, the curriculum has pivoted from teaching students how to do the work to teaching them how to supervise the machines. Ethan's education is no longer about the brute force memorization of statutes. It is about the mastery of predictive analytics. In his family law simulation lab, Ethan uses software that can ingest 10 years of a specific judge's rulings and predict a potential outcome for a custody dispute with a staggering 92% accuracy rate. This has fundamentally changed the historical study of the divorce lawyer. The lawyer is no longer a gambler relying on intuition and experience. They are a data scientist managing probabilities. Step by step, the law school curriculum has integrated AI into every facet of domestic relations. The first step was the automation of discovery. In the 1990s, a divorce lawyer might charge a client hundreds of dollars an hour to have a junior associate read through thousands of emails to find evidence of hidden assets or infidelity. Today, Ethan is taught to deploy autonomous agents that can scan millions of data points across a couple's digital footprint, social media, banking apps, smart home logs, and even car GPS history, in a matter of seconds. The Academy teaches students the ethics of digital surveillance, focusing on where the line between aggressive advocacy and a violation of privacy is drawn in an age where the machine sees everything. The second step in this educational revolution was the automation of property division. Law schools in 2026 have introduced advanced courses in algorithmic equity. Students like Ethan are trained to use optimization engines that can calculate thousands of different ways to split a marital estate, accounting for tax implications, future inflation, and the volatility of cryptocurrency. Imagine a scenario where a couple owns a fragmented portfolio of non-fungible tokens, shares in a private aerospace startup, and a traditional 401k. In the past, this would have required months of negotiation between competing accountants. Now, Ethan is taught to feed these variables into a neutral arbitrator AI that proposes a split, designed to minimize the total tax burden for both parties. The divorce lawyer's role has shifted from being the one who does the math to being the one who negotiates the parameters of the algorithm. However, this reliance on code has created a new and dangerous challenge that the Legal Academy is desperately trying to address: the black box problem. If an AI predicts that a mother should have primary custody based on its analysis of her behavioral data, but the lawyer cannot explain the logic behind that prediction to a human judge, the system fails. Consequently, a massive portion of the 2026 curriculum is dedicated to explainable AI in family law. Ethan is taught how to deconstruct an algorithmic decision and translate it into a human narrative that resonates in a courtroom. This is the birth of the hybrid lawyer, someone who can speak the language of the machine but also the language of the heart. The data regarding the impact of AI on the legal profession shows a paradoxical trend. While the cost of mundane tasks like document drafting and asset tracing has plummeted, the value of the human-to-human interface has reached an all-time high. Law schools have responded by making emotional intelligence a core, graded requirement. In 2026, Ethan spends as much time in a psychology clinic as he does in a computer lab. The Academy has realized that while an AI can divide a bank account, it cannot sit across from a grieving parent and provide the empathy and strategic counsel required to navigate the destruction of a family. This has led to the rise of the lawyer as philosopher. Students are taught to grapple with the deep existential questions of the divorce process. What is the true value of a relationship? How does the law define a successful life after a split? A pivotal case study currently being taught in 2026 is the 2024 New York matter of Harrison versus Harrison, which was the first major case where an AI-drafted settlement was challenged on the grounds of algorithmic bias. The AI had inadvertently used historical data that favored the higher-earning spouse, leading to a lopsided distribution of future earnings. This case forced law schools to implement mandatory training on bias detection. Ethan and his classmates are taught to audit their AI tools for gender, racial, and socioeconomic prejudices that might be baked into the underlying data sets. The divorce lawyer of today is being educated as a guardian of the code, ensuring that the machine-led future of family law does not repeat the systemic inequities of the past. The pacing of the profession has also accelerated. In the historical study of the divorce lawyer, the process was often defined by long periods of waiting for a court date, waiting for a response to a letter, waiting for a check to clear. In 2026, the legal education system prepares students for a world of instant litigation. With the rise of the private digital judiciary, cases can be filed, mediated, and settled in a single weekend. Ethan is trained in high-speed negotiation, learning how to make strategic decisions in real time, as the AI updates its predictions based on every new piece of evidence introduced during a session. This requires a level of mental agility and technological fluency that would have been unimaginable to the lawyers of the 20th century. But as the algorithm becomes the dominant force in the classroom, a final chilling question remains. If the machine can predict the outcome, and the machine can divide the assets, and the machine can draft the agreement, what is the ultimate purpose of the divorce lawyer? Is the profession simply being liquidated by the very technology it embraced? The Legal Academy's answer to this question is found in the final, most prestigious course of the degree, The Ethics of the Human Override. We are about to enter the final chapter of our 100-year study. We have traveled from the shadow of the 19th century divorce mill to the sterile high-tech efficiency of the 2026 algorithmic courtroom. In the final part of this masterclass, we will pull all these threads together to reveal the ultimate future of the American divorce lawyer. we will explore the final reckoning between the legal establishment and the rising tide of self-representing litigants who are using AI to bypass the bar altogether. And most importantly, we will answer the question that started this journey. In a world of perfect data and instant splits, will we still need a champion for the human soul? The conclusion of the historical study is not what anyone expected, and it involves a secret movement within the elite law schools that could change the definition of a lawyer forever. We are going to the end of the line. We are going to the end of the line. As the year 2026 unfolds, the American legal education system has reached a terminal velocity where the rapid integration of technology has collided with a profound, almost desperate return to the human element. To see this in action, imagine a law student named Jordan. Jordan is a final-year student at a top-tier institution like Yale or Stanford. While his peers in 1926 were memorizing the rigid doctrines of fault and his predecessors in 1996 were mastering the forensic audit of physical files, Jordan is part of a radical new curriculum called the Humanist Rebirth. This movement is the secret heart of modern legal education, a reaction to the realization that while algorithms can process data, they cannot navigate the moral and emotional wreckage of a dissolved life. Another significant trend in 2026 is the rise of the unbundled legal service. Data suggests that as AI has made basic legal tasks free for the public, the traditional law firm model is collapsing. In response, law schools are teaching students how to provide high-value surgical interventions. Imagine if Jordan doesn't take on the whole case. Instead, he is hired for a single, high-stakes negotiation or a complex ethical consultation. This requires a level of specialized expertise that the previous generations of generalist divorce lawyers never had. The Academy is training students to be master consultants who can step into a digital-first divorce and provide the strategic, human-centric guidance that a computer cannot offer. Furthermore, the historical study of the divorce lawyer in 2026 must account for the total collapse of the traditional courtroom for family matters. Almost all domestic cases are now handled in private, digital arbitration centers. This has forced law schools to focus heavily on the art of the virtual presentation. Jordan is trained to manage his digital presence, learning how to project empathy and authority through a screen. He is taught how to use real-time sentiment analysis tools to read the emotional state of the opposing party during a Zoom-based mediation. This is the ultimate evolution of the lawyer as a diplomat, someone who can navigate the digital landscape while maintaining the gravity of a human advocate. This era also sees a fascinating historical echo of the early 20th century. Just as the elite schools of 1900 tried to distance themselves from the shysters of the divorce mills, the elite schools of 2026 are trying to distance themselves from the low-cost legal bots. There is a new prestige associated with the human lawyer. Having a human represent you in a divorce has become a status symbol of the wealthy and the intellectually sophisticated. The legal education system has leaned into this, branding their graduates as the elite curators of justice. This has created a two-tiered system that the Academy is currently struggling to reconcile. How do you ensure that the benefits of the humanist rebirth are available to the average person, and not just the clients of the high-priced advocates like Jordan will soon be? As we look at the data from the final semester of 2026, we see that the most popular course in the country is now the philosophy of the family. Law students are returning to the classics, studying the history of marriage as a social contract and the evolving nature of human commitment. This is the final synthesis of our 100-year study. The divorce lawyer, once a pariah in the legal community, then a scientific technician, then a financial gladiator, has finally become a student of the human condition. The Academy has realized that the law is not just a set of rules to be applied. It is a shared language for resolving the most intimate of human conflicts. The secret movement within the elite law schools is not just about technology or ethics. It is about the survival of the profession itself. By moving toward a model of holistic advocacy, the legal education system is betting that no matter how advanced the AI becomes, humans will always seek out other humans to help them through their darkest hours. Jordan's graduation in May 2026 represents the beginning of a new epoch. He is not just a lawyer. He is a specialist in closure, a professional trained to turn the end of a marriage into the foundation for a new, stable reality. But even as this new era begins, a shadow is falling over the horizon. The very definition of a family is about to undergo another radical transformation, one that will make the same-sex marriage movement and the no-fault revolution look like minor adjustments. The rise of synthetic humans, AI companions, and the legal recognition of non-biological sentient entities is already beginning to populate the hypothetical scenarios of the next generation of law students. What happens to the divorce lawyer when one of the parties is inhuman? How does the law of domestic relations adapt to a world where the boundary between biological and synthetic life is blurred? The historical study of the divorce lawyer is far from over. In fact, we are standing on the threshold of a new, even more complex legal wilderness. In our next masterclass series, we will dive into the emerging field of synthetic domestic relations. We will explore the first cases of AI-human separations and the legal battles over the custody of digital consciousness. The tools of 2026 are already becoming the relics of tomorrow. Stay with us as we uncover the next stage of the evolution. The future of the family is being written in code, but the pen is still in the hand of the human advocate. For now,